Good morning, good morning, good morning. Or should I say, hear ye, hear ye. It's day 22 of the Karen Read Retrial, and I think this is the Commonwealth's last witness because we are with accident reconstructionist and biomedical engineer, Dr. Welcher. I think it's also witness number 38. We have lots that have happened. Dr. Welcher gave his opinion that Karen Read's car was not damaged by hitting John O'Keefe's car. He gave the opinion that the injuries on John O'Keefe's arm matched geometrically to Karen Read's vehicle. And he gave the opinion that was then stricken that Karen Read struck John O'Keefe with her vehicle. We will get back into that today because that was at the end and that was stricken. And I was very put off by a number of things by this expert, including that he said that is what happened. John O'Keefe was struck by Karen Read's Lexus. That is what happened. That is an expert testifying to an ultimate fact for the jury. He can have an opinion that John O'Keefe was struck by a car and that the damage to the car and the damage to John O'Keefe are consistent. I don't know how he'll get there, but if he can explain it, but he can't say, yeah, Karen Read hit John O'Keefe with the car. That's what happened. And that's what he was trying to do yesterday. And this is an expert who has testified numerous times. He should know better. I don't even know. I've never seen an expert attempt to testify to the ultimate fact because they're so conscientious of what their role is and the fact that they're there to inform the jury and help the jury make decisions, not to act as the jury themselves. So the only way to solve it, I think, is to go to court because it's time to go to court. And for all of you asking, could that cause a mistrial? The defense did not ask for a mistrial. The defense does not want a mistrial. All that happens if you get a mistrial is that this jury gets dismissed and you start all over again in a few months. That is 100% not what the defense wants. And it's not enough that's going to cause a dismissal. So we'll finish up direct. We'll get to cross. And that's going to be where we, I think, spend the entirety of today. Because I think we're just about done with the Commonwealth's case. Are they going to rest today?
Do you have an opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it.
What? Is it your opinion that the damage to the Lexus is consistent with striking John O'Keefe? Well, there's two theories on that, sir. Sir, the jury instruction for beyond a reasonable doubt literally says if there are two reasonable explanations for an event, you jury, you must pick the one that points, and in some jurisdictions it says to innocence, and in some jurisdictions it says to not guilty. So your opinion is could be that there's multiple things. Do you have an opinion about whether the damage to the Lexus is consistent with striking John O'Keefe? This is wild. Brennan asked the question really clearly this time.
The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
Do you have an opinion whether, based on the data and based on the physical damage and your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe?
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
To a reasonable degree of engineering
It's
certainty.
too early.
Whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022.
Yes,
What's your opinion?
that it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
And
That
is
was at least a
specifically
clearer
pertained to
opinion.
January. Thank you, Dr. Welcher.
My
Your Honor,
pleasure.
I would move the evidence subject to redactions. Dr. Welcher's PowerPoint presentation.
Time for cross.
Morning, Dr. Welcher.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Lessie. Nice to meet you.
Nice to meet you.
Alessi.
Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in
gonna
any
be a weird
forensic
day.
activity in your profession?
Yes, the general umbrella of you basically coming in, giving scientific evidence in court applies to forensics. So my main job is accident reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court.
Or your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office
I was wondering
to
about that.
conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea. I don't get the billing or the statements.
How much did you pay for the Lexus? But how much did you pay for the Lexus?
Do you recall whether Aperture has...
David,
Well,
that's
do
true.
you believe Aperture
Distracted
is
preteens would
working
probably answer
for
more
free
directly.
in this matter?
Oh, no.
Oh, I don't believe he was paid $44,000. I think they have probably been paid more.
Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And
really?
isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So the Commonwealth
Mention it all. Mention it all.
What?
is obligated to pay at least $325,000. And is that correct?
That is you're asking me a legal opinion now about a contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that,
That's not a legal opinion. They put down a $44,000, it seems, retainer and authorized a contract for $325,000. So when I was yelling about whether or not Aperture was padding their bill or was overcharging or was overworking on things that didn't need to be charged, I was asking about the rate they were charging for Burgess based on Burgess's education or debunked education. I was curious about Burgess doing all of the work to re-download and fly to get stuff from Karen Read's Lexus that had already been downloaded. I was interested in how much was going to be billed. Well, now we know. Up at least $325,000. So, Burgess did a lot of work that I don't think he needed to do. I don't think the jury gives a shit about any of it. I'm kind of stuck on it. The jury's not going to care. Why does it matter? Because they're going to charge a lot more than ARCA did. And it's really rare for the defense to get to ask government experts this, because most of the time when you have a trial, the government experts are law enforcement. And so if the accident reconstructionist comes from the police department or law enforcement, it's like, did you get paid for this? Yeah, I got paid the same thing I get paid every day. I am on salary. I just get a paycheck. It's rare to have government experts that are getting paid this much. Occasionally you will have a doctor come in who's an expert. They're getting paid for a day or whatever, but it is incredibly rare that in a criminal case, the defense gets to ask the prosecutor about spending this much money. A lot of agencies would not approve spending this much money. I think it's telling that they did. And for the jury, it's like, so somebody else already did this work, and now you're paying you to do this work. And the defense is going to loop that back around, I suspect, to argue they didn't like the answer from Trooper Paul. So they spent $325,000 plus to go get the answer they wanted. That's where the argument's going to go. And it's more than ARCA. So when the government starts going, you're getting paid, so you're getting paid, so you're swayed in the direction of the person that's paying you, this kind of locks out that argument because it comes back around, right? Okay, well, if you're going to argue that ARCA's being paid for an opinion and they're just going to give the opinion of the person that's paying them, isn't this the same? That's a lot of money. That's a lot of money. Right, and it's the government. They trust that they're going to get paid. It's going to take a while, but they trust they're going to get paid.
That there was a purchase of a Lexus exemplar.
That's what I want to know.
For your testing?
Correct.
Who pays for that Lexus exemplar?
Yes, I want to know.
Aperture.
And is that then
Reimbursed?
cost passed on to the Commonwealth?
No.
Really?
So you pay for the Lexus, you don't pass that cost on, correct?
So what we're doing is we paid for the Lexus. We're keeping it till the trial's over. We're selling it and charging the Commonwealth the difference in the price.
Exactly.
Well, that seems relatively fair for all of it. So they're going to sell it. Hopefully not internally, but they're going to sell it and then they're going to bill the Commonwealth for the difference. That makes sense. And the Commonwealth will pay for it, but will pay for less of it. Okay. That's fair. That makes perfect sense. They're not going to keep it and they're not going to charge the Commonwealth for the whole thing. All right. That's fair.
That was where I was going, sir.
But they're only paying the difference. So
that's better than I thought.
In theory, if we sell it for more in California, then we'll reduce the bill.
Okay, I don't want to speculate. I just wanted to see what the obligation was.
So the obligation is the difference.
Exactly. So the obligation is the difference.
Whenever you're ready, Mr. Alessi.
Thank you, Your Honor. And if I could please address an administrative matter that I wish I didn't have to address.
An administrative matter that I wish I didn't have to address?
Dr. Welcher was just using, at least my observation, his computer. He still has monitors on his desk. Could we have all that removed, Your Honor?
Yes.
Closed. Yes.
Would he open?
So did you just turn it on?
No, but I will. I closed it.
It's preposterous.
Like want the computer all the way off or just everything?
Is he going to need to turn his computer back on?
I do not see a need for the computer to be turned on. Do we have the ability to put the presentation and documents from our
So I'm going to see counsel at sidebar,
Sure.
please.
This should have been done before the jury came back. And Alessi is right. This has been an ongoing issue. This is why most experts will bring a binder or a printout of their presentation and not be operating it from their own devices. We are now at lunch on day 22 with Dr. Welcher still on the stand on cross-examination now with attorney Alessi. I think this witness will be on the stand the rest of the day. I'd be surprised if he finishes before the end of the day. But I'm pretty sure at this point, I am feeling very confident in like weather forecaster terms that this is the last witness for the Commonwealth. I think we are just about at the end of their case. The court did indicate tomorrow would be a half day to the jury. I don't know if that means it will be a half day for the lawyers as well, or if the court is going to take care of housekeeping items in the afternoon before we move into the defense case in chief and the defense witnesses. So now that we are on to cross-examination, some of the parts of cross we've gotten very, very lost in the weeds. There are things about this expert that just frustrate me. He has been admonished by the court numerous times to stop looking at his computer. At one point, she told him to just close it, and he didn't. And as Alessi's asking questions, he's still like searching through the computer on the stand to look for things. It's incredibly frustrating to watch him refuse to just sit there and answer the questions. He's like, no, I'm going to search through and find this. It is not an open book exam. It is cross-examination of expert testimony. That is, in fact, based on your memory and the work that you did. And if you need to refer to your report, there's a process for that, saying, I need to refer to my report. And then if the defense says, no, we're moving on, then you're moving on. We are now at the end of the questioning for the morning. Attorney Alessi is asking about the experiments that were done. We are talking about the spoiler or the fin from the top of the Lexus that was in some of the photos yesterday, and injury to John O'Keefe's eye, and whether those things lined up. But I think the point that Alessi made that was quite good, I just hope it doesn't get lost in all of the arguments over physics equations, was you did all of this assuming that the Lexus and John O'Keefe were at the same level. And that's my summary of it. You did all of this experimentation and measuring, assuming that the Lexus and John O'Keefe were both at the same level, street level, essentially. And that's the same for the arm hitting the taillight. But Alessi asked, okay, how high is the berm? And he said, and the berm curb, same thing. And it's a small rounded asphalt curb that just goes into lawn. There's no sidewalk or anything beyond that. And he said about 4 inches. And we started getting into, okay, but you didn't account for if John O'Keefe was standing up on the lawn. And the expert said, well, I didn't account for if the back of the SUV was up on the lawn and if the tires were spinning on the curb. Well, then, I mean, if there were tires spinning on the lawn, there would be evidence of tires spinning on the lawn, one would think. And we didn't see any evidence of that, and there's been no discussion of evidence of that. I am curious if after lunch we will get to Alessi arguing the same thing or asking the same thing in cross about, well, if John O'Keefe was standing on the yard, on the lawn, then if he's 4 inches up from the street, doesn't that change where the taillight would contact with his body? Like completely change it. And for the first time we heard this expert say, for the first time we heard anybody say, that John O'Keefe was 7 feet from the road. Exactly 7 feet. 7 feet from the road, southwest of the flagpole. And he said that he got to that from descriptions, from the video, from first responders, from where the flagpole is. And that's where he tagged that 7 feet from as the point of rest. We also saw earlier on in the questioning today, Alessi starting to get into questions about the timing of what key cycle and where this collision with John O'Keefe is supposed to have happened. And the expert was very clear and repeated himself numerous times. We do not know when John O'Keefe was struck by the car. We know he was struck by the car, but we do not know when in time that happened. So Alessi was trying to get through the questioning about Trooper Paul's report and the Commonwealth's shifting timeline and said he was going to come back to it. I think we will see him coming back around to that after lunch about which key cycle was aligned to what incident in Trooper Paul's report. But Alessi's going to have to go about that questioning a bit of a different way. And I imagine over the lunch break, that's exactly what he's going to be thinking about, is which way he wants to approach the differences between Trooper Paul's report and analysis and this witness's report and analysis. This witness said he reviewed Trooper Paul's report. He did not say he relied on it to do his own analysis. So there's going to be some questioning about, I think, the differences. But Trooper Paul's testimony is not in this case, and Trooper Paul's report is not in this case. So it's more of a narrow a needle in a thread type of questioning that's going to happen with that. I was surprised at how much the court had to admonish this witness. And the court interrupted sua sponte, meaning on her own, to tell the witness to stop looking at his laptop. I am flabbergasted that that had to happen more than once, but the court admonished this witness in front of the jury numerous times about referring back to his report. I think the cross got very lost in the sauce on the questions of physics. I think getting into, well, you only accounted for one possibility and there are numerous possibilities is a very good line of questioning for the defense. It is the Commonwealth's job to close the doors to all possibilities but one. And this witness has said numerous times, it could be this, it could be this, it could be that. We don't know exactly how this happened. The witness also said in his earliest testimony this morning on direct that it is his opinion that the taillight on Karen Read's vehicle would be broken from a collision with John O'Keefe so long as the vehicle was going more than 8 miles an hour. You're sitting there going, Emily, did he explain how that happened? Did he explain the amount of force that was needed to break the taillight? Did he explain why 8 miles an hour was the number, where you drive by and everybody sees you? No, he didn't explain any of that. And maybe it'll come up again on cross. I hope it does. And he also explained that he believes the injuries to John O'Keefe are consistent with being struck by a Lexus identical to Karen Read's, and those are his opinions. I'm interested to see after lunch if the cross gets into why 8 miles an hour and the force needed to break the taillight. Oh, I left something out. The witness also said, because so much has happened today, the witness also said this morning, well, there were two theories about the damage to Karen Read's taillight. A glass being thrown at the taillight and hitting John O'Keefe. There were two theories about it. And Brennan actually had to work pretty hard to come back around to get this expert's opinion that the damage to Karen Read's car could be caused by John O'Keefe. Because his initial answer was, well, there's two theories on how that happened. The glass being thrown at the taillight is going to come up more, I think, in the defense case. But if there's two theories of how it can happen, are you closing the door to all other possibilities? Or is the jury going to sit there and say, okay, well, John O'Keefe could have thrown a glass at it, could have hit it with his arm. Either way, it's still the car impacting with John O'Keefe. I don't know. It depends on how many doors this witness is able to close. But he has said repeatedly, we do not know how exactly John O'Keefe was positioned when this glancing collision happened. We do not know where exactly he was positioned. We do not know what speed he was hit at. There's a lot of we do not knows on how this happened. So after lunch, what do I hope to see? I hope to see questions about the force and or velocity and or some explanation for how 8 miles an hour is where that taillight would break. Like, what is the strength of that taillight? What kind of force does it take to break it? I have questions. I hope that we will see more questions about the paint arm experiments and what happens if John O'Keefe is on the lawn. Doesn't that shift the entire thing? I hope that we see more questions about braking systems, because it came up very briefly and Alessi moved on beyond it. But this witness did offer that one of the reasons head injuries may not be the most common type of injury we see in pedestrian versus vehicle collisions is because the vehicle technology has changed and advanced braking systems and advanced pedestrian braking systems in forward collisions have gotten so good that there aren't as many catastrophic crashes. But he said that those systems are different when backing, and there was no follow-up question to it. I'm very much hoping that someone asks a follow-up question about the braking systems on the Lexus, because this is the first time anyone has addressed in either trial the fact that the Lexus had advanced braking systems. I'm going to check my notes because I want to make sure I didn't call it the wrong type of thing, because there were multiple systems that he talked about in the vehicle. Sorry, not advanced braking systems, pre-collision systems. This is why we take notes. And he started talking about the Lexus having a pre-collision system if it senses a pedestrian in front of the car. And then they moved on. I very much want to know what the Lexus is equipped with for backing. Because if the jury, I can't imagine that the jury is sitting there going, but does that exist when you reverse? Does it beep if there's something behind you? Because most cars do. And this is a newer vehicle. So what if any testimony will we hear about if there is a pre-collision system or what type of sensors they are if a pedestrian is behind the vehicle? And does that change if a pedestrian is to the side of the vehicle, as they are saying? I think those questions need to be answered, because most jurors, if they are driving modern cars, are going to think of their own experience driving. So I think it's a question that has to be answered, because some cars are going to alert you differently than others. And if the jury doesn't have an answer, they're going to fill in the gaps on their own. And it's the job, I think, of the Commonwealth to fill in those gaps and answer those questions. And that's probably why Alessi didn't follow up on the question, though I desperately wanted him to. Because if he doesn't know what the expert's going to answer, he's not going to ask this expert. He's going to ask his own expert. And that's what I want to hear more about. So does Karen Read's car beep when there's someone behind it? Is that true if something is to the side? Does it have braking when you are backing up, or is it only a forward pre-collision system? We'll see if they address it after lunch.
I'll just call it the blue paint exercise. Is that descriptive enough for you to know what I'm talking about?
No, it's not an exercise, it's a test.
Now, did you conduct that test in an attempt to show that the injury patterns on Mr. O'Keefe's right arm are consistent with being struck by the Lexus taillight on that arm?
So generally, I wanted to show that the location, area, and span over which that headlight covers matches the location and area of the lacerations on his arm.
That's what I want to get to.
That's exactly what he wants to
So
get to.
you discussed data that
He wants
you
to
say
show that
shows
they match. Right.
that you say shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is
yeah,
that
he didn't
correct?
say that.
No, where'd you get that from?
Hold on. Okay. The answer is no. So did you do a test involving 20 miles per hour?
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
I want to know more about that.
Let me ask you this. Mm-hmm. Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you
Of course.
do that? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. I was not going to hit myself with a Lexus at 20 miles an hour.
You could have done other tests where the vehicle was going at 20
Could you have
miles
used
per
other
hour
things?
if you used a crash test dummy, correct? You could have done that.
If you used the right crash test dummy, and then to set up the test, because generally you only get 1 or 2 shots at it, because you damage the car, you have to know everything about the parameters. And so, again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able.
This is the point. This point. We might not have gotten test results that we like. And then we would have to come in here and explain why the test results are different. We don't know how it's going to turn out. So we're not going to do it.
Is that in the yellow there? Is that 87, sir?
It is.
Okay, is that the 87 number you were
Hold
referring
on a
to?
second. You asked me to identify. So then it's, see where the one next to it says minus 53?
Yes.
0.429. If you go up, so it's not a little bit down, a little bit, and add, see where it's changing directions at 34.157?
Yes.
You add those two together, that gives you the same result. So it went 34 feet forward and then 50-something feet backwards.
Right. And what is the 87 feet traveled, is that what you're indicating is the distance traveled during the trigger? Is that what the 87 represents to you?
That is so 87 represents the total rearward distance traveled during the trigger.
Okay. So you believe
What?
87 represents the total rearward distance. Did I hear you correctly?
Correct.
Now,
That's not what
Can
you
you
said on
Just
direct.
hold on, to be clear.
That's
so
not what you said.
It starts, it pulls forward, then it backs up, passes where it initially started, and goes 53 feet further back.
that's what I want to get to. How many feet did you say on direct, and did you just say now that it went 87 feet in reverse?
That's what he just
Correct.
said.
Okay.
From its furthest point forward.
Well, that's what I want to get to because I want to have this point clear.
Interesting.
How many feet do you believe the Lexus went in reverse?
He just
based
said 87
upon
feet.
your PowerPoint presentation. Not what
Yesterday, I thought it was 53 feet backwards. And now we're at 87 feet backwards, which is staggering.
when it went forward and then came backwards. How many feet do you believe that vehicle went in reverse?
Your question doesn't make any sense because when it went forward,
How many motherfucking feet in total did it go in reverse? From the point that it started reversing. How far in reverse total? So you go forward, that's forward. And then you go reverse. How far in reverse? How is that the question that doesn't make sense?
then it went in reverse.
Right. And the forward motion doesn't count as reverse. Holy shit.
How many feet do you believe the Lexus went during the trigger?
So it went a total of
So
80.
that's a
It went
different
34
question.
feet forward. Then it came back 80 or another 50.
So it went 34 feet forward, 34 feet backwards, and then another 50 blah, blah, blah backwards to get to 87. So literally, you take one step forward, two steps back. 30 forward, 34 forward, 34 backward, then an additional 54. 87 feet is a long way backwards.
3 feet past where it went.
Exactly.
Exactly. That's exactly what Alessi was asking. Where the fuck do you have room to back up for 84 feet?
So,
Wow.
you've testified that the 1162
Where?
trigger event represents a backwards maneuver, correct?
So again, that was clear. It initially pulls forward and then backs up.
Dr. Welcher, do you recall that from your January 30th, 2025 PowerPoint?
I thought I had replaced the video on the left-hand side by the time I produced it.
Sir, I got to
don't
go through
recall
this
that.
quickly. That image is a drone image on the left, correct?
Oh,
I thought I had replaced that from the time I produced it, was the answer.
correct.
And you had that in your original report, but you removed it in subsequent reports, correct?
Correct.
Where did you get that drone image from?
It was in the file.
Wasn't it in the CARS report of Trooper Paul?
I believe it was.
So you took that drone image from the car's report of Trooper Paul, correct?
Correct.
Let's, if we could, Mr. Woke, go to diagram 1. Do we have that electronically of Trooper Paul's report?
The question I want so much is, the Commonwealth told you to remove slides based on witness testimony you couldn't include. Was everything they asked you to remove from Trooper Paul? Did the Commonwealth ask this witness to remove information from Trooper Paul so they could show that this witness didn't rely on information from Trooper Paul to narrow down the line of questioning? That's what I want to know. That's what I want to know.
Do you recognize that as diagram 1 from Trooper Paul's report?
Yes.
So, and that's the diagram that you took that image and you put it in your January 30th, 2025
I'll take the
PowerPoint,
compliment.
correct?
Pulling up my version of PowerPoint.
Looky here. Remember yesterday when I lost my mind and I'm like, why is the shoe there? The shoe was in the road. And I went on for way too long about it. I completely fucking forgot this diagram. This is Trooper Paul's diagram. Look at where everything's lined out in Trooper Paul's diagram. Ding, 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 ding. Exactly in the same place. Tell me again, sir, that you didn't rely on Trooper Paul's report, because those are in the exact same place.
Rise to the jury.
All right, tomorrow's a half day. The lawyers aren't done. The jury is out. It sounds like we're going to move ourselves to a Voir Dire.
You see this first page, do you recognize this as the cover page for the Trooper Paul report that I was referring to?
Can you show me the signature?
You want to look at the report, sir? I'm not so sure there is a signature on the report.
Oh, he's allowed to be on the laptop this time. The court said he could use his report while they were being questioned about this outside the presence of the jury for the voir dire. The court told him he could.
Page 16.
Can I have that?
Yes.
Because he's being
Now, what I want to do,
he is being questioned about very specific things outside the presence of the jury, and they need to answer they need to move through this quickly. So letting him have his laptop is fine.
is to go to diagram 1.
And it's going to be faster.
Republish what was just up. I'm showing you diagram 1, sir, and I'm asking you, is that the image from Trooper Paul's report that you then used to put into your January 30th slide presentation?
No. See all the writing on here, the glass cup, all the dimensions here. Here's my January 30th one. None of that stuff's here. None of this stuff is here.
Isn't it the case that this is
You
cropped more and
incorporated
there's
it.
a larger picture of the same image or not?
See this tree?
Yes.
See these trees?
Yes.
See all these measurements by the trees? All
Yes.
these? That's right here.
Okay.
Those do not show up on my image.
Let me go to a different method then to do this. You have an image.
You incorporated
Can
it.
we go, Mr. Wolf, to the January 30th presentation?
Slide 36.
Correct.
Oh my God.
Where did you get that image from? That's in your
Is it
PowerPoint
not incorporated?
presentation on the left.
I think it was from the file, a satellite image from the file.
What part of the file, sir?
I actually don't know at this time.
How close is the image on diagram 1, the drone image, to the image that you can't now recall where you got it from for your slide presentation? Are they similar?
So that one has a whole bunch of measurements
Oh my
and
God!
ID on it, but the underlying image is very similar. It's probably the same one.
Do you know of any other location other than Trooper Paul's report that you could have got that drone image from?
No, I'm not sure I got it from the report. I recall getting it from the file. So this image is not in that report.
It's not my
Yes, it is. You asked me anything but the report. That image is not in that report.
Did you get the drone image from any file from the Massachusetts State Police?
Yes.
Okay.
Where? Where?
Trooper Paul work on any drone images to your knowledge with respect to 34 Fairview?
I don't know.
But you would agree that the drone
he doesn't
images are from the Massachusetts State Police file, correct?
Give me 1 second. Yes, it came in a file called cars-trp.jopal.
Okay. So it came from, and that's the report of Trooper Paul, correct?
No, these are drone images that are not in the report.
No, I'm saying what you just read. Can you repeat it again, what you just read, where it came from?
I read you a folder
Yes.
that contains a bunch of things, including the report.
Understood.
That image is not in his report.
Okay. Can you read the file name again that you just read?
The folder name
Yes.
is cars-trp.jopal.
Okay.
So it's
And
from his.
did you get the drone
file.
image from that file folder?
I did.
Okay. Thank you.
You're welcome.
Now let's go on to the May 26, 2025
So it's from Trooper Paul's
PowerPoint
file.
that you created. And I'd like to go to slides 25, 26, and 27.
I just want to know if he was told not to use anything.
Have
from
you
Trooper
discussed
Paul's
with
report.
anybody today at all the source of what is depicted up on this slide?
No.
Okay. So let's now go to where did you get you see the larger chart to the left there in the, looks like mostly a rectangle. Do you see that, sir?
What slide are you on? What slide is that?
25, I
25,
believe.
okay.
Okay. And then if we could click to 26, because it looks like it's the same. If we can go to 26 and 27.
I saw somebody
looks like
saying
it's
he's
the same
protecting his
one. You tell
paycheck.
me.
Y'all, he's going to get paid either way.
Similar.
He's going to get paid
Similar.
either way.
Okay.
Yeah.
In 27,
Correct.
see the same or similar one there. Okay.
These are all from Google Maps.
Well, my question is, may I approach, Your Honor?
Yes.
Thank you. Let me ask you this so I don't have to keep going back and forth. Do you have access, sir, to the CARS report of Trooper Paul on your computer?
Yes, he does. It's in the folder. The
remember
folder
the
says
name of it?
cars,
I don't.
Dot,
with a hard copy. Mr.
Trooper Joe Paul.
So, if I
And
could,
he said
approach, Your Honor?
Yep.
it's
So
in the
you see
folder.
what I'm pointing to right here, which is page 10 of Trooper Paul's CARS report. Do you see that?
Is this the same report? It's dated 1/29/2022.
I believe so, sir. Let me just take a peek. This is, if you can just compare, this is the one I have in my hand. Take it and look for any identification that gives you, right? We got the same one.
Yeah, mine's broken.
Okay,
So that's the paper.
okay. So we have that report, and I now am referencing page 10 of that report, and I'm looking at the chart on page 10. Is that chart on page 10 the same or substantially the same as the chart that is up on your slide presentation right now?
So it's not the same. I did not use this data at all, but we both use Google Maps.
Okay. Alrighty. Now let's go to
The Google Maps
your,
point is fair.
continuing on the same slide, if Mr. Woke, we could go to slides 22 and 23.
Okay.
Okay, and this will be the last on this, Mr. Alessi. If you want to get to the autopsy photo, we're wrapping this all up at 4:10.
Okay, Your Honor. You see the photos that are up on that?
I do.
Okay. Do you, in terms of those photos, do you recognize any aspect of those photos?
Yes.
What do you recognize in terms of the person in it?
You want me to limit it to just these 3 photos?
Yes.
Any photo that would be, this photo or any photo similar to it. But let's start with just these 3.
If I have to limit it to these 3, I don't know who that is.
Okay, and if you don't limit it to those 3, who would you conclude it is in those photos?
It appeared to be Trooper Paul from other photos.
Okay, so you can tell from other photos that this is Trooper Paul in these photos, correct?
Well,
I
there
have
it
photos of
is.
Trooper Paul in the car. I don't know that someone else switched out. I have no reason to believe this isn't anybody but Trooper Paul.
Okay. Would you have any understanding that there's any other trooper that would be doing this type of analysis other than Trooper Paul?
Someone else took the photographs?
No, I'm talking inside the vehicle.
I'm sorry?
Inside the vehicle
Someone
doing
else
what's
would have to be in the
depicted
photo
here.
to take the picture, to be fair.
Someone is inside the vehicle taking the photograph.
What's your
Yeah, that's
best
fair.
conclusion as to who that is?
Trooper Paul.
Thank you. If you can go, Mr. Woke, to slide 131 of Dr. Welcher's PowerPoint presentation. And it's now 132. I don't believe that's the right one. It's the,
One before that.
yep, I think you're, yeah, okay. So this is slide 131 from your slide presentation, correct, sir?
Correct.
For that depiction, that is from Dr. Scorty Bellows' autopsy report, page 3, correct? Is that where you got that from?
It's from the report. I'll take your word for it on page 3.
So, but it is from Dr. Scorty Bellows' autopsy report, correct?
Correct.
Now, if you could go to, if we could zoom back out
Okay.
and go to the multicolored image in the center,
Yeah, where did that come from?
up at the top. If you can go to the very top line, it says autopsy report performed by Irene Scorty Bello, MD, PhD. If you could scroll back over.
Date of autopsy.
Date of autopsy, January 31, 2022, and then you see final diagnoses. That is all directly from the autopsy report, is it not, sir?
Yes.
And that is in your slide presentation, correct, sir? This is
Correct.
page 131 of your slide presentation, correct?
Correct.
That's all I have, Your Honor.
Okay.
They went to sidebar when they were talking about the findings of the coroner. So him relying on the coroner's report and using it in his report opens the door for him to get back into that line of questioning.
Did you have any questions, Mr. Brennan?
If it'd be helpful to the court, I have a couple quickly.
Okay.
Can I keep it under 2 minutes?
This witness will be back tomorrow.
Dr. Welcher, you were shown a photograph of the street of Fairview Road. Did you know that didn't come from Trooper Paul? It came from the CERT report, and Trooper Paul then took it from the CERT report and put it in separately in his presentation? Did you know that?
I had no idea. I just was given it as a folder.
And the photo you were using,
So Paul grabbed it from the CERT report? Interesting.
it didn't have the markings that Trooper Paul put on his report, did it?
It did not.
When Trooper Paul, when you used that photo, was it because you were borrowing, relying on, or using any of Trooper Paul's reports for your conclusions or any of your decisions or analysis in this case?
I did not use his report at all.
It was simply limited to the use of the photo to show a different demonstrative issue.
correct.
And then when you saw diagram 1, again, that was different than what was used in Trooper Paul's report because it
Yes,
had
they're leading. It's Voir Dire. The court's in a rush. No one's going to object.
absent in it all the writing. Isn't that fair to say?
That's fair to say.
Did you rely on Trooper Paul's analysis or conclusions in this case for your conclusions and your analysis?
Not at all.
Is that why you went and downloaded the information and looked at the car and did everything individually, separately, and uniquely from Trooper Paul?
I wanted it to be independent in my analysis.
He's trying
Regarding
to keep that door
Dr. Scotabello,
closed.
did you ever consider her conclusions regarding manner or cause of death as a basis for your analysis and conclusions?
Yes.
And when you considered her analysis, did you consider the conclusion of undetermined cause of death, was that part of your analysis?
Oh, no, I was using like the skull fractures, the description of the injuries.
So you were considering the information in her autopsy report?
Correct.
How about her conclusions? Did you rely on her conclusions to do your studies or any analysis in this case as far as cause of death or manner of death?
Only I thought I said blunt force trauma and hypothermia.
Okay. Regarding her conclusions about whether this was caused by a car accident or not, did you consider that as the basis of your opinion?
No, I wouldn't take a person like that's opinion for that.
Did you ever have a conversation with Dr. Scortabello about her expertise limitations?
Sir.
No, I would want a biomechanical analysis.
Was your opinion regarding the collision in this case, did it have anything to do whatsoever with Dr. Scortabello's conclusions regarding cause of death, whether it was accident, undetermined, or homicide?
No.
Okay.
Thank you. Yeah, Your Honor.
All right, one question. Can we just wrap it up? I'd like to hear you argue, but we don't have time, so I'm just going to...
I have
Decision.
two questions, Your Honor. You put in your slide presentation information from the autopsy report of Dr. Scortabello for a reason, correct, sir? And that reason is because you considered the autopsy report as part of your analysis, correct?
So I considered portions, which are the portions I included here.
Right, so you considered it.
The autopsy report.
And part of those considerations were the final diagnoses.
Were the
we put that
findings.
back up, Mr. Woke?
Right, were the findings.
But you recall the slide that you had has the final diagnoses of Dr. Scortabello, and you put that in your slide
Right.
presentation because you considered that as part of your analysis, else it wouldn't be in there, correct?
So the final diagnosis is in there. There's a line, then it says cause of death, and then manner of death.
Right.
The things I highlighted are the things I thought were important. So the highlighting on slide 130. So the final diagnosis, again, does not include cause of death. It does not include manner of death. There's that horizontal line demarcating those. The important things that I was looking at are the under or highlighted, which is why I highlighted them.
Exactly. So the ones that you highlighted,
You
you
considered.
considered are from the autopsy report. That's why you're highlighting them, right, sir? You
Correct.
considered them.
Correct.
Thank you. No
You're welcome.
questions, Your Honor. I
All
appreciate
right.
that opportunity.
So I'm not going to let you argue now. I'll hear you very briefly tomorrow before we stop. But
Okay.
Mr. Alessi, how much longer are you going to be?
I'm about halfway through, Your Honor.
Halfway
I think we're going to pick
through.
up look for it tomorrow. If we can get some things quicker, I would like to do that. But given today, that's my best estimate.
So
This is Accident Reconstruction.
we're half a day tomorrow.
Oh, that's right.
So it may be that we have a 20-minute break tomorrow, and we finish up by 1:30 by going straight through. We've got a juror who has an appointment
That's why they're
that
a
we
half
told
day
her she'd be
tomorrow.
able to make.
Yeah.
So
That's why they're a half day tomorrow.
I'd like to do everything we can so that Dr. Welcher doesn't have to come back or stay here another day. So let's just see what we can do, and we will do the same thing for your experts as well.
No, I understand, Your Honor, and I respect everything that Your Honor is saying. I must say, Your Honor, to state the obvious, this is the key aspect of the case.
Yes.
And we've got to be able to proceed through with the questions.
They need the time they need.
On is direct and be properly.
And I'm not asking you to curb it. I'm just hoping that we can do it. So I will ask you tomorrow at a certain time to see whether we're able to do it with the 20-minute break and finish.
Fair enough, Your Honor.
Okay.
That would be my answer if that's the point.
Okay.
Maybe
All right,
instruct the
thank
witness
you.
to answer directly.
Thank you, Dr. Welcher.
So at the end of day 22, there was a brief voir dire between Alessi and Dr. Welcher. And at the end of that, Attorney Alessi said he's about halfway done with cross, and the court reminded everyone that tomorrow is a half day and they're going to try to be done by 1:30 because there is a juror who has availability scheduling issues in the afternoon. It seems that perhaps this witness could go into Friday if there is another day of cross-examination from the defense. The defense wants to lock in answers, which has not been easy with this witness, to lock in answers on the key points before their experts testify. Because they don't want this witness coming back on rebuttal and being like, well, no, it's this, and no, it's this, and no, it's this. They want to hammer it down so that he can't move the goalpost if he comes back in rebuttal to rebut ARCA. You need to lock those answers in. And that has not been easy with this witness. There were parts of the cross-examination that were horribly clunky and wandering. And then there were parts of the cross-examination that made the points the defense is going to want to argue. It's just going to come down to whether the points that the defense wants to argue, the jury is even going to remember before they come back to closing argument or not. I think the points of the cross that were much more powerful were when they were talking about the assumptions that the expert made. You assumed this, but you didn't consider this. What about the amount of force it takes to break an arm? What about the 8 miles an hour that's going to break the taillight? How did you even decide that? How did you decide that the point of rest of John O'Keefe was 7 feet from the curb line or from the street? How did you make those decisions? And there were aspects I wanted to see the defense come back around to, and we learned, I think, during the voir dire why they didn't. There was a voir dire, which must have been what the court decided at sidebar, about Trooper Paul's report. How much of Trooper Paul's report was used will be important to how much the defense can ask about it. We know the defense wants to ask a bunch about it, and we know that the Commonwealth wants to ask none about it. I have to wonder, and this is purely my speculation and wondering, I have to wonder if the experts from Aperture were cautioned not to rely on or incorporate or use Trooper Paul's report so that this wouldn't come up. I don't know if they were. I don't know if they weren't. But the witness was incredibly defensive about it not being in Trooper Paul's report and was very specific about it. That's not in his report. That's not in Trooper Paul's report. Everything else, he's like, I'm not sure if it was there. I'm not sure if it was from here. I'm not sure where it is. But he knew 100% what was not in Trooper Paul's report. So I just wonder if it's a point of contention. Let's go back and see what Brennan said in that first question.
It didn't have the markings that Trooper Paul put on his report, did it?
It did not.
When Trooper Paul, when you used that photo, was it?
That's fair. When you used it, it didn't have the markings from Trooper Paul's report. Okay, that's fine. It didn't have the markings from Paul's report, but it's still in the folder because it's still the photo. And the markings that he put on it and the markings that Paul put on it are the same. In that voir dire, they also asked about a bit about what he used from the coroner and what in the coroner's report was integrated into his slides. And we did see them question about that. And he said, yeah, I did look at the coroner's findings. I still think this is the Commonwealth's last witness. I don't know if we'll be done with this witness tomorrow, but court's going to be done before lunch. They're going to take a 20-minute break and court's going to be done. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.